Hi, my name is Quinn, and I'm a student at the Indigenous Community Legal Clinic, also known as the ICLC, in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Stolo Nations. This video is part of the Live Law series on tenancy and housing. In this video, we're going to talk about evictions under the Residential Tenancy Act, particularly the reasons why you can be evicted. If you're not sure what the Residential Tenancy Act is, or whether the Residential Tenancy Act applies to your housing situation, I suggest that you first check out the Residential Tenancy Branch video in this series. Keep in mind that even if your landlord says you don't fall under the Residential Tenancy Act, or the RTA, you should not just take them at their word. They might be confused, or they might want to stop you from exercising your rights under the Residential Tenancy Act, or they just might be unaware of the law. So, now let's turn to the topic. Why can your landlord evict you? Under the Residential Tenancy Act, the RTA, your landlord can't just evict you without a reason. The RTA sets out the reasons that you can be evicted. Knowing these reasons is important because it affects how many days notice your landlord is required to give you, how many days you have to dispute the eviction, and by when you need to move out. Let's look at the first reason. Reason 1, for cause. For cause basically means that they have to have a reason to evict you. For example, you've been repeatedly late paying rent. Maybe you've damaged your rental unit or the building. You've unreasonably disturbed or significantly interfered with your landlord or neighbors. You've broken an important rule in your tenancy agreement. Or you've engaged in a legal activity that negatively affects your rental unit, the building, your landlord, or other occupants. Your landlord has the burden of proving that they may have cause to evict you. This may be hard for your landlord to do, and you may be able to relatively easily dispute the eviction if you apply to the Residential Tenancy Branch, the RTB. To evict you for cause, your landlord needs to give you 1 month's notice. If you want to challenge the eviction for cause, you need to apply to the Residential Tenancy Branch, the RTB, within 10 days of getting the notice. And those days include weekends and holidays. So you have to move quickly. If you don't dispute the eviction, you usually have until the last day of the month to move out. Let's look at another reason. Reason 2, non-payment of rent or utilities. The RTA states that a tenant must pay their rent in full and on time, regardless of whether the tenant believes the landlord has fulfilled their obligations. Your landlord can evict you if you don't pay rent in full, even if you're just a few dollars short or if you haven't paid utilities for more than 30 days after getting a written demand for payment. To evict you for non-payment of rent or utilities, your landlord needs to give you 10 days notice. Once you get the notice, you have just 5 days to pay up to cancel the eviction, or 5 days to apply to the Residential Tenancy Branch, the RTB, to dispute the eviction. If you do neither, you will need to move out within 10 days of getting the eviction notice. If you do not pay rent within those first 5 days, or apply for dispute resolution, your landlord can apply to the RTB and ask for what's called a direct request, which is an ex parte process. This means your landlord can then ask the RTB for an order of possession for your unit without you actually participating in the hearing. So that means that the arbitrator will make its decision based solely on the landlord's evidence without hearing your side. If you pay rent within those 5 days, we still recommend that you apply for dispute resolution so that you have the opportunity to tell the Residential Tenancy Branch that you actually paid. Otherwise, your landlord could lie and apply for that direct request we just talked about. And since you won't be allowed to appear or participate in that hearing, your landlord might lie and say they never received the rent. Here's another reason. Reason 3, landlord's use. Your landlord can evict you if they, or a close family member are going to move in. A close family member can only be the landlord's father, mother, child, or spouse. Your landlord must give you 2 months' notice for this type of eviction. After receiving the eviction notice, you'll have 10 days to dispute the eviction by applying to the residential tenancy branch. If you do not dispute the eviction notice, you must move out within 2 months of getting the eviction notice, probably by the last day of the month. Because you are being evicted for a reason that has nothing to do with your behavior, you are entitled to 1 month rent as compensation to help you with the financial burden of moving. Your landlord must either pay you this money or give you the last month's rent free. Keep in mind that some landlords say they're evicting you to use the property, but then don't. For example, maybe they actually evicted you so that a new tenant could move in and your landlord could raise the rent. Your landlord must begin to use the unit for their own use within a reasonable time of the effective date of the eviction notice. Your landlord must then use the unit for at least 6 months. If your landlord does not do these things, then you may be able to apply for compensation equivalent to 1 year's rent. Moving on to a fourth reason for eviction: demolition, renovation, repair, or conversion. Your landlord can evict you if they have all the permits and approvals required to demolish, renovate, repair, or convert your rental unit. However, the work being done needs to require the unit to be empty. Your landlord must also be acting in good faith. This means that they can't have a hidden motive for evicting you, and they can only evict you if the unit really has to be empty for the work to be done. To evict you in this situation, your landlord must give you 4 months' notice. If you want to challenge the eviction, you need to apply to the residential tenancy branch within 30 days of getting the notice. If you don't dispute the eviction, you must move out within those 4 months after getting the eviction notice, usually on the last day of the month. Like with a landlord's use eviction, you're entitled to 1 month rent as compensation to help with the financial burden of moving. As with landlord's use, your landlord within a reasonable time needs to do that work that they said they were going to do in your eviction notice. If they don't actually do it, you can again apply and get 1 year's compensation. That 1 year is the equivalent of 1 year of rent. Okay, and now reason 5. Your landlord can evict you if you no longer qualify for subsidized housing. But your tenancy agreement must clearly say that your tenancy will end if you no longer qualify for the subsidy. To evict you in this situation, your landlord must give you 2 months' notice. If you want to challenge the eviction, you need to apply to the residential tenancy branch within 15 days of getting the notice. If you don't dispute the eviction, you must move out within 2 months after getting the eviction notice, usually on the last day of the month. Let's now do a quick recap. We've looked at 5 reasons that you can be lawfully evicted: for cause, for non-payment of rent or utilities, for your landlord's use, for renovations, repairs, or demolitions, or because you no longer qualify for subsidized housing. There may be other reasons that your landlord can lawfully evict you, like if you used to but no longer work for your landlord. The key takeaway is this: if you get an eviction notice from your landlord, make sure they have a lawful reason for evicting you. Remember that the timeline of your eviction will depend on the reason. How long you have to dispute the eviction will also depend on the reason. To learn more about how your landlord can make you leave and how you can dispute an eviction, check out the video in this series called Eviction Step by Step: The Who and the How. Also, just a note, if your landlord gives you an eviction notice and it tells you by when you need to move out, you can move out earlier, but you still need to give your landlord the notice required. If you get a notice to end tenancy and are not sure whether you have grounds to dispute it, a good strategy is to apply to the residential tenancy branch for dispute resolution as soon as possible and within the deadline stated in the eviction notice, which can be as little as 5 days. Then you can seek legal advice. We recommend this strategy of applying to the RTB right away because it preserves your remedy. If you're trying to decide whether to apply to the RTB but then miss the deadline, you're unfortunately out of luck and can't challenge the eviction at the RTB. If you're wondering if your eviction is lawful or want help disputing your eviction, we we recommend that you contact the Tenant Resource Advocacy Centre, commonly known as TRAC. TRAC has a team of lawyers and legal advocates who can provide free legal representation to eligible tenants living in British Columbia. You can start by calling TRAC's helpline at 604-255-0546 or 1-800-665-1185. To inquire about free representation at a RTB hearing, you can also contact Access Pro Bono's Residential Tenancy Program at 1-877-762-6664, extension 1500. If you've already been to the RTB and lost and are now at risk of losing your housing, you can contact the Community Legal Assistance Society class at 1-888-685-6222. If you're Indigenous, the ICLC is also a good resource. So is the Law Students Legal Assistance Program. Thank you for watching.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.